Warning, censorship. Warning, censorship.
Hey there, Keean Bexte for Rebel News with a story that you are not going to want to miss. I'm suing Justin Trudeau and his cabinet. His attorney general is responding in the federal court after we pushed an application to a federal judge for them to declare Justin Trudeau's COVID jails, his COVID gulags, unconstitutional. We're making a lot of applications, asking a lot of these judges, and I want to walk you through what exactly we're doing, why we're doing it, why it is so important. And it's not just for us. It's not just so that when we go back to the United States to report on issues and topics that many Canadians and Americans rely on Rebel News to do. It's not just so that when we come back, we're not going to have to go to a COVID jail again. We're doing this for every Canadian that happens to be outside of the country for any reason. There's one individual who was actually in San Francisco seeing their son before they passed away. This is an issue that every Canadian might have to deal with. You hope that you might not have to, but every Canadian is at risk of Justin Trudeau's absolutely insane, unconstitutional laws and regulations that he has set up, which has seen Canadians lose their liberty and security and financial assets because of Justin Trudeau's vanity project, because of Justin Trudeau's distraction from his failures during this pandemic, most notably vaccine procurement. This is all a distraction. Don't misunderstand it for anything else. I want to walk you through our lawsuit that we have taken to federal court. It's a strong lawsuit, and I want to explain to you what it is. And then we're going to have our lawyer, our superstar lawyer, her name's Sarah Miller from Calgary. She is on the case, and she's going to talk to you and me a little bit about why we're doing this, what we're doing exactly, and what we hope to achieve. So without further ado, I want to open up the actual lawsuit document, the application we brought to the federal court for you to look at, and I'll walk you through it here. So of course, it's the federal court, it's Rebel News Network, and me actually suing the Attorney General of Canada, which basically means we're suing Justin Trudeau and his cabinet for a bunch of different reasons, basically because of these COVID jails, and because we think they're unconstitutional. So, of course, this first application is saying that we think that they're using powers that they don't actually have to lock Canadians up in a quarantine facility. They call it, they're really COVID jails. And Section 2 here is really, I think, one of the most interesting parts of this lawsuit. And I'll read it to you. A declaration, this is what we're seeking, a declaration pursuant to Section 52 of the Constitution Act 1982, being Schedule B of the Canada Act 1982, UK 1982 C11, that the sections of the accommodation order, which is what we're suing over, which requires quarantine at government-authorized accommodations or quarantine facilities, or include government-authorized accommodations in a quarantine plan, are inconsistent with Sections 7, 8, and 9 of the Charter and are in no force or effect. This is really the kicker of our application to the federal court. If a judge agrees with this section, it is saying that what Justin Trudeau is doing is unconstitutional, which would be a massive blow to Justin Trudeau, to his government, to his ego, and to his polling numbers, because it will be proof that Justin Trudeau has confiscated the rights, the charter rights that his father actually signed into law. He confiscated those from Canadians for no reason, for no reason that makes sense, at least, and no legal reason, that's for sure. Now, Sections 7, 8, and 9 of the Charter of Rights and Freedoms, I'll read them out to you. 7 is everyone has the right to life, liberty, and security of the person. They can't be deprived of that. Section 8 is everyone has the right to be secure against unreasonable search or seizure. And Section 9 is everyone has the right not to be arbitrarily detained or imprisoned. These are very basic rules that Canada operates by. They're the fundamental freedoms that we enjoy in Canada, and Justin Trudeau has trampled on them. And I think that a judge will look at the evidence that we've outlined here in this document and say, yeah, this is obviously an issue. We need to act quickly. We need to act urgently. And the goal here is for the law to be slapped down, for a judge to sit Justin Trudeau down and say, no, you can't do this. You can't violate basic rights of Canadians to cover up your own failures. Now, there's a lot of reasons that we're saying this is a problem. And one of the main reasons is that this doesn't achieve what Justin Trudeau has set out to achieve in the first place. He says that this is to stop the spread. for some reason he thinks Canadians coming from the United States are more risky, despite the fact that to get onto the plane back into Canada, you must have had a negative test. I had to take a COVID swab into my nose. It sucked. You can watch it right here on screen. I had to take this test while I was in Florida. Upon landing, I had to take another, and then 10 days after, I had to take a third. I was the most COVID negative person on planet Earth after all that testing had been completed. But Justin Trudeau didn't care. He still threw me in a COVID gulag and made me pay for it, and didn't give me a refund after I only needed one night of those delightful accommodations. So in doing that, not only was I not able to just go home, quarantine, and not see a single soul, I had seen no less, no fewer than 14 different individuals. Many of them I was in very close quarters with. One of them I was in an elevator with twice. Another I was in an elevator with him once as they took me to and from my room. It was an absolute joke. It's a disgrace of a government program, and we are going to court to prove exactly that. And the person that is helping us in court is Sarah Miller. I'm going to bring her on the call right now to speak with her.
Now, I just want to talk, about some of the specifics of this case, and in particular, I want your help in explaining to our viewers what it is we're applying for, because it's not what others, because there's other people fighting a sort of similar legal battle, but we're taking a bit of a different strategic approach, and I was hoping you could outline that for our viewers. We're not looking for an injunction. We're looking for something else. Can you explain the reasoning behind that and what we're looking for?
Absolutely. So an injunction is a very high standard test to meet. It's not likely to be successful in this case. And so our legal team strategically decided not to pursue an injunction, which is an interlocutory decision. Rather, what we've decided to do is just pursue a hearing on the merits, which means a final determination of whether or not this order in council, which mandates people to stay in these hotels, is legitimate, or if it's unreasonably infringing on charter rights. So we decided strategically not to pursue the injunction, and I think that turned out to be the right decision based on today's court proceedings.
Yeah, so we're not asking for an injunction, but what we are saying is that these quarantine facilities that are, I think, in general, are less effective than it would be if we just went home. We're saying that this whole program, this scheme that Justin Trudeau's cooked up, is unconstitutional in the first place.
Yes, absolutely. So the order in council is issued by cabinet, and it lays out a number of requirements for people returning to Canada via aircraft. And we're saying that all those provisions that require a traveler to quarantine for 3 days in a hotel are contrary to charter rights. And of course, as we all know, charter rights aren't immutable, but the violation here we've decided is too great. And so that's what we're looking for, is a court to agree with us to declare that the order, as it relates to the 3-day quarantine period, is unconstitutional and is not reasonable in with respect to what they're doing.
And I think that latter part that you mentioned is a big part of it, because it's not only is it not reasonable, I think it's ineffective. And we mentioned that in our application to the court, the federal court, that I had to deal with in this time that they forced me into this. I call it a gulag. He calls it government approved accommodations. I was in close contact with 14 people who I wouldn't have been in close contact if I was allowed to continue my participation in the provincial program that I had registered for, and the province had told me I was A-okay to do, which was basically a 7-day quarantine at home. What do you make of that?
Yeah, absolutely. It is ineffective. Now, to part of the legal test will touch on whether or not the law is effective. More importantly, the other part that you mentioned is that the province has this under control. The government of Alberta had an alternative. A number of provinces have issued alternatives to this 3-day hotel quarantine. And so that in and of itself is an infringement on what is properly before provincial governments. And the other aspect of this is that it's not that it's ineffective, it's arbitrary and disproportionate. the test doesn't really consider the fact that it's ineffective, although possibly it should. But the legal test does consider whether or not the law is arbitrary, overbroad, disproportionate, doesn't have a rational connection to the purpose of the order. So all of those things really cause this order in council to be quite questionable, and I think that's clear from the huge public outcry about it.
No, I'm really excited about this case. I think that we have a good case, and I love hearing it from the lawyers when they say, "Yeah, we're going to win." But I know we never really know what's going to happen in court. But what do you think? Do you think that we have a good case? We're standing on a good footing here.
Yeah, I think increasingly the courts are starting to see that these orders have been overbroad, they've been overreaching, and I think that they're slowly coming around. So I think this is really good timing for a case of this magnitude. If we had filed this at this time last year, when everything was more uncertain, I don't know that I would feel as certain about the outcome. But in this case, I think that the order in council with the hotel quarantine is a violation of charter rights. It'll really, I think, depend on the decision maker as to whether or not they find it a justifiable infringement. Obviously, in our pleadings and in my opinion, we've argued that it is not justifiable, but that will really come down to our decision maker.
Sure. So, just for our viewers' sake, what's the timeline that they can expect an update or movement on this case?
Yeah, so we've been in contact with the Attorney General, and they have put forward a timeline where all of our matters will be heard concurrently on June 1st, 2021. So still, a couple months away, but given the delays in court, especially caused by COVID, June 1st is a really great date to receive for the hearing of this matter. And although the current order in council with the hotels is scheduled to end before that, this will be a very important decision going forward for all the other restrictions that might come down the pipe with respect to COVID or any other future pandemics or government action. So
you make a very good point there that this is a huge precedent-setting case because, and I think a lot of Canadians are concerned about, well, this was the first pandemic that we've had to deal with in our lifetime, and it could be any natural disaster really that we have to deal with in the future, and the government is going to look at the rights that they confiscated from us in this case and say, oh, well, we can maybe go even a little bit farther next time if Canadians were complacent and if courts allowed it. So I think that this fight is really important. I'm so glad that we have you fighting this fight for us in the courts because we know how successful you guys and your firm are. So thank you so much for your help on this case and for joining me here today.
Absolutely. Thanks, Keean.
Now, this lawsuit, like I said, it's not just for us. It's not just for us at Rebel News. We are fighting for every Canadian that might have to or already has had to deal with Justin Trudeau's unjust laws and regulations, which sees them being abducted by government agents, thrown into COVID jails without their families' understanding, knowledge, or permission, and without their own permission. They don't have an opportunity to say, no, I don't agree with this. And if they do, they're threatened with massive fines. We are doing this for them. If you want to help us do this, and we do need help, we can't do this alone. Sarah Miller, God bless her, she's doing great work, but she costs a lot of money to do the work that she's doing. I think this is important. This is precedent setting, not just for right now, for these COVID jails, but for the next COVID jails, the next gulags that Justin Trudeau sets up for whatever reason he thinks he has the right to do. If we don't challenge this now, he could do this again. If a judge doesn't say right now that this is wrong, Justin Trudeau will do this again. If you go to nocovidjails.com, it's really important that you do that. Go check out all of our coverage on this. And if you can help us out, cover the cost of these lawyers so that we can take this case to the end, so that we can sit Justin Trudeau down ourselves and a judge will say, no, you can't do this. This is wrong and this is illegal. It is unconstitutional. That's what we want to happen and we need your help to do it. Go to nocovidjails.com. For Rebel News, I'm Keean Bexte. Thanks so much for tuning in. Like I said, please go to nocovidjails.com. Check out the work we've been doing. And if you can, we need your help. We can't do this alone. If you can help us out, please pitch in.